Hey everyone, you probably remember how Bill 96 in Quebec raised lots of frustration, and not only in Quebec, but around Canada. If not, go online and write Bill 96 Ribbon News, you will find out fairly quickly. Bill 96 was adopted on May 24th and started to be applied on June 1st. This law is a bill that Mr. François Legault claimed to be respecting French, the official and still most common language of Quebec. One thing that Mr. Legault doesn't mention, though, is that this will at the same time infringe on the right and freedom of the native people, Anglophone and allophone. Oh, by the way, I want you to let you know that in order to fight this discriminatory bill, we at Ribbon News started a petition that you can find at stopbill96.com. So please, if this issue concerns you, go check it out. It is stopbill96.com. Today, I will present to you an exclusive interview with Julius Grey, Canadian lawyer and university professor. He is known for his expertise in constitutional and human rights law. He is one of the people involved in the lawsuit against Bill 96, but also Bill 21, which claim to be put in place to ensure the respect for secularism of the government. Please welcome him as he is sharing with us what the lawsuit is all about. I saw recently you raise your voice against Bill 96. I know you are some of you with other citizens who joined the lawsuit. Can you explain why you decided to go further on this?
I think it is a terrible law. It has no basis. In fact, the theory that French is declining in Quebec is incorrect. And as long as Bill 101 remains for schools, there's no way it's going to disappear. But secondly, the law is bad for everybody. There's no winners. It's bad for Anglophones, certainly divided into two groups and with services reduced, but it's also bad for Francophones. Francophones are being discriminated against with respect to possibilities of learning English and also possibility of using their English to advance. It's not good for the majority. It's also bad for the immigrants and the allophones. So it's bad for everybody. The intentional removal of the Charter of Rights doesn't work for everything. It doesn't work for the justice part. But the intentional removal of the Charter is always a very disturbing phenomenon. The government knows that it's against the Charter, against our basic fundamental principle, and it goes ahead nevertheless. Like in Bill 21, it's something that is, as I said, disturbing. It should be completely unusual, but unfortunately, it's not now. As for the justice part, it's not covered by the notwithstanding clause, so I think chances of winning this are very, very high. But let's add something else. Our system of justice has a lot of flaws. It's expensive. It's bureaucratic at times. It's slow. But one thing that worked perfectly was the bilingualism. There was no problem with the use of the two languages in Montreal. So what do? Instead of attacking accessibility and smoothness of operation, they're going after the language in order to reduce access for some and to make it less easy to express themselves for certain people before the courts. I went through this law several times, and except for one portion which talks about teaching French and making French lessons accessible, there is nothing in it that is positive. It is a law that intellectually and morally impoverishes Quebec. all people in Quebec.
What is the main consequences that the English speaker are facing with the Bill 96?
Well, English speakers are they're reducing the number of places, or at least they're preventing growth in cégeps. English speakers are, more importantly, facing considerable loss of services in the medical field, the legal field, and in dealing with the government. Now, the government says it's not so, but it was challenged over and over again. If it's not so, if medical services are not going to be affected, put it in the law. They wouldn't. And today, the Collège des Médecins sent a circular to doctors saying that instead of just passing a French test at the beginning of a career, they can be re-examined anytime if somebody complains, if somebody doesn't like it. I mean, it clearly means that, first of all, some doctors may say, why should I continue here? Because doctors, of all people, can find employment in other parts of Canada. Secondly, it's just not fair. And so people are going to be losing doctors, medical services, and so on, legal services, and ability to express themselves before the court. When you're dealing with the administration, only the so-called historic Anglos, people who have a right to send their children to English school, will be able to deal with the administration, and immigrants only for 6 months. Now that is preposterous. The fact that you don't have the right to go to English school doesn't mean that you don't feel more at ease dealing with your doctor in English when you're ill, or dealing with the government in English when you have a tax problem or a criminal problem or a regulatory problem. So the Anglophones are just losing services, and they're being divided into two groups in an arbitrary way that is really ridiculous.
Mm-hmm. So what is the percentage of chance that your lawsuit can win in court?
Well, I don't like to play prophet. I never did. From the beginning, I know that every lawsuit can be won and every lawsuit can be lost. And it doesn't depend on how hard you work or how well you do it. It depends on the spirit of the times, on which judges you get, on how good a day you have, but although that's less important. However, I think looking at the case, on the issue of the judicial remedies, on the right to prevent the Office de la Langue Française from inspecting lawyers and notarial offices and files, on the constitutional amendment, which is also not covered by the derogatory clause, I think the chances would have to be considered good.
Mm-hmm.
The others, it's difficult. I don't think our case is the one that's going to determine the derogatory clause, because the Bill 21 case is ahead of us. It's already coming up in the Court of Appeal in November. So most likely, this will not be the major issue in the Bill 96 case, although you never know. Still, that's a more difficult proposition. Mm-hmm. But as far as justice, constitution, legal privilege, I think the chances of winning are good.
Mm-hmm. So if I understand, you are a part of the lawsuit against Bill 21 as well.
Well, yes, I represent some of the intervenants, two of the intervenants. So it's equally bad. It's the discrimination against women teachers who have the veil, or policemen who have a turban, or people with kippas is completely unacceptable. But and the use of the notwithstanding clause is as bad there as here. So yes, I'm involved in both. But I think we should change the legislative culture of Quebec. I think we should make it clear that derogatory clauses are useful for surgical precision to get one particular point that you can't yet afford or that appears to be unacceptable. But they're not acceptable as a sort of general clause to be used in all legislation which you consider important. And think about it. The government did not use the derogatory clause when it passed the emergency COVID decrees. It did not use the federal government did not use the derogatory clause when it invoked the Emergency Act against the Ottawa truck drivers. It appears that all of these very urgent matters don't require the derogatory clause. Yet the use of another language than French does add to that the powers that are being given to the Office Québécois de la langue française far exceed the search powers of the police when they're investigating a murder, and yet in the case of a criminal investigation or valeur mobilière investigation, the charter is there. Mm-hmm. And here they're giving vast powers of inspection, invasion without the recourse to the charter, unless, of course, the courts restore it. So it is a very frightening and a sad situation. Quebec should not be there. Quebec is a developed, democratic, open place, which unfortunately has legislated in a populist and unacceptable way. I hope the courts correct it, and I hope sooner or later voters also pronounce themselves, and we will go back to being an open and liberal society.
Mm-hmm. What would be like the meaning of the society if both of the case lose?
Well, it would mean that we have gone back to a notion of parliamentary sovereignty that most countries, Western countries, got rid of because they realized the danger of the tyranny of the majority. So the United States in 1791, but other countries through the 19th century and the 20th century, and especially the 1960s, 70s, United Nations adopted a charter and so on, realized that parliamentary sovereignty is not all it is. And now it appears that Quebec wants to go back to some sort of majoritarianism. But there's one more thing left. When M. Bourassa did the same thing with the Signs Law, I was one of the lawyers who took Mr. McIntyre to the United Nations, and we won. And Quebec agreed when an international tribunal told it that you couldn't do it, not under the Quebec Charter, but under the Universal Declaration of Rights. Quebec complied. And I think there is very serious possibilities here of a return to the United Nations Tribunal.
Mm-hmm. Do you have a message to tell all Canadians about these bill that Quebec tried to pass?
Well, I'll have a message, which is my message. It's not necessarily everybody's message. I'm not a person who's a collectivist or communitarianism. I'm not doing it as an Anglo. I'm as much of a Francophone as an Anglophone. I want both languages. I'm doing it because of individual rights and because of justice, because it's the weak who are going to lose their access to the courts. It's the poor who are going to have worse medical services. It's those who work hard and learn English among Francophones who are going to be deprived of an asset which should help them in their career. So it is an individual rights matter, a fundamental individual rights matter, and it affects everybody. It's not English against French. It's everybody against a form of populism.
My last question would be, do you think this bill of Bill 96 will be more an handicap for Quebecers than something good for them? Example, for the economy, as well as information, as well as a lot of different things, when we think that most of Quebec people would only speak French. And,
I think it will be very bad for most Quebecers, maybe not right away. These things are trends, and I don't think you'll notice something in a year or two. But I think in general, nationalism and religious politics end up hurting the majority group. If you look at what happened in various countries, the majority group ended up less well off, whether it's the Serbians or the Germans or the Italians and so on. Nationalism ends up depriving you of the sort of worldliness that it takes in a modern society. So, yes, I think this law is particularly harmful to the Francophones. I'd also say it's particularly harmful to people like me who want to live in both languages. There's only one place in the world, maybe Ottawa and Moncton, maybe, but there's only one place in the world really where it is easy culturally and in terms of employment to live both in French and in English, which I consider the two great languages of the West. It's Quebec always says we are the only Francophone jurisdiction, but we are also the only place where people like myself can find a place, people who want both French and English, and they shouldn't take it away from us.
As you know, this law, Bill 96, is really discriminatory for English speakers, and we want to fight it. So please go and fill our petition at stopbill96.com and please sign it massively so we can send them a really important message to stop this discriminatory bill. Stopbill96.com.